Good afternoon and welcome to Division 4 of the Court of Appeals. My name is Bob Hawthorne. To my right is Judge Stephen Bernard. To my left is Judge Ted Tao. We comprise Division 4 and will be the division ultimately rendering an opinion in this case that we have on our 130 docket. And that would be the case of Rocky Mountain Hydro Seeding versus Bellissimo. I see counsel are set up and I presume are ready to have oral arguments this afternoon. Let me ask you first, have you had a chance to look at our policies and procedures before the Court of Appeals, and do you have any questions about any of that?
Yes, I have, Honor. I have any questions. With me here by way of introduction is Tina Garski, the principal of Rocky Mountain Hydro Seeding.
Okay, thank you.
And yes, I've had a chance to review the policies as well. We have no questions.
Okay, thank you, counsel. And I'll remind you that your time, counsel, is self-monitoring for the appellant in case you want to have any time for rebuttal. You can watch the time on the podium there, and each side has a total of 15 minutes argument, of course. Let me remind you that we are live streaming oral arguments these days. I don't believe there's anything confidential or sensitive in this particular case, but be aware that the arguments are being live streamed. As for those folks that are in the courtroom, please make sure that you have any cell phone or other devices turned off so that they will not disturb counsel during their arguments. And with that, unless there are any other questions, the court calls the case of Rocky Mountain Hydro Seeding versus Bellissimo, 17CA1806.
May it please the court, my name is Nathaniel Walshine, bar number 46611. I represent the appellants in this matter: Bellissimo Incorporated, Bucking Horse LLC, Bucking Horse Farm LLC, Side Hill Residential Association Incorporated, and Johnson Farm LLC. I will be referring to the appellants as Bellissimo during the course of today's proceedings. The issues for this court are: 1, did the trial court err in determining that Bellissimo had an obligation to pay its subcontractor, Rocky Mountain Hydro Seed, or Rocky Mountain? The answer is yes. The trial court ignored the plain language of the contract that provides that Rocky Mountain was required to pay its suppliers and submit lien waivers prior to receiving payment. 2, did the trial court err in determining that Rocky Mountain's numerous breaches under the subcontractor agreement were not material, because its findings were not supported by the evidence, and because its decision was based on post-filing conduct?
Counsel, let me interject there and ask you, on page 5 of your opening brief, you write that the court found that Rocky Mountain Hydro Seedings breached the agreement under Section 2, Paragraph 1, Section 2, Paragraph 2, Section 2, Sub A, Section 2, Sub E, Section 5, Paragraph 2, Section 13, and Section 14, and several provisions of Attachment D. Yet the record citation only reflects a finding that the technical breaches alleged were not proven.
Yes, maybe I can fall on my sword a little bit there. The record citation and the findings were based on what defendants had argued at trial. It was a recitation of what defendants had argued at trial. The trial court's orders on what breaches of the subcontractor agreement occurred and whether or not they were material follows shortly thereafter in the trial court's order.
Thank you.
Thanks. So getting back...
Pardon me, Mr. Walsh, I'm sorry to interrupt you, but how much of a problem is it in this case that work starts some of the work starts before the contract is even entered into. There was an agreement, an oral agreement, but the contract isn't finalized until August, right? And there was some work that was done before that. How big a problem is that?
Thank you, Your Honor. Here, the effective date of the subcontractor agreement was, I believe, dated to May 5th, which was before when the contract was, or when any of the work was performed under the subcontractor agreement.
I understand that.
Okay.
But my concern is this. A lot of the work gets done and some of these problems arise before the contract is signed. How much of a problem is that for your position?
I don't believe that's a problem for the position. I believe that if you have a contract and it's signed with an effective date that occurs before the work, and it's clear that the parties had a binding contract, that was how they were going to handle their obligations and their rights, that would be binding both in equity and in contract. There's no principle that would reject the idea that the contract loses its binding effect based on what occurred prior to its formation, especially where here the parties had copies of draft contracts and there was very little negotiation related to the subcontractor agreement.
Thank you.
Thank you. So turning back to materiality, the trial court erred in determining that Rocky Mountain's numerous breaches under the subcontractor agreement were not material because its findings were not supported by the evidence and because its decision was based on post-filing conduct. Number three, the third issue for the court is, did the court err in determining that Rocky Mountain was excused from performing its obligations under the contract? The answer is yes. Rocky Mountain was not excused from performing half the contract, especially where here, after Rocky Mountain walked off the job, Bellissimo hired a separate subcontractor to perform all of the work Rocky Mountain was hired to perform. And here, Rocky Mountain used the wrong mulch on the work it did do without submitting the required written change order. The fourth issue is, did the trial court err in finding that the mechanics lien filed by Rocky Mountain was not clearly excessive? The answer is yes. The lien improperly included attorney's fees and/or late charges, which is clearly excessive as a matter of law. We therefore ask this court to reverse the part of the trial court's order entering judgment in favor of Rocky Mountain on its claim for breach of the subcontractor agreement. Reverse the part of the trial court's order finding that the mechanics lien asserted by Rocky Mountain was not excessive, and reverse that part of the trial court's order awarding Rocky Mountain its attorney's fees and costs and denying Bellissimo its attorney's fees and costs on its counterclaim that the mechanics lien asserted by Rocky Mountain was excessive. I'd like to turn, with my remaining time, to the breach of contract and subcontractor agreement claim. Basic contract law requires a different result under these facts than what the trial court found. Here, Rocky Mountain performed half of the landscaping work in a week, used the wrong mulch, stopped the work, submitted an inflated invoice, and refused to continue work or pay its supplier without the inflated invoice being paid.
But that didn't occur until after Bellissimo refused to pay, isn't that correct?
I don't believe that's correct.
The trial court found, as I understand it, that Bellissimo's decision not to pay anything, even the undisputed amounts, was the first material breach, and thus any further performance was excused. Is that the trial court's ruling?
Yeah, the trial court found Bellissimo had an obligation to pay, and that excused Rocky Mountain's further performance under the contract. What occurred here was Rocky Mountain had performed half of the work in a week and submitted an invoice a couple weeks later, then refused to submit a mechanics lien waiver, didn't pay its suppliers, didn't provide any of the requirements under the contract under the monthly payment checklist and attachment F of the contract, mechanics lien waiver in section 6. They didn't comply with these material terms.
Why are they material breaches, as opposed to just breaches that you get an economic offset for that essentially the trial court ruled?
Well, Your Honor, I disagree with you that the trial court provided some sort of offset here. But I want to turn to your question and talk about why those terms are material. The trial court's analysis on that issue was based on post-filing conduct. The court essentially looked at what occurred after the case was filed, including the dismissal of a counterclaim by Bellissimo and the settlement of the subcontractor and supplier's mechanic lien issue as the basis for determining that that wasn't material. The materiality of contract terms must be assessed in the context and in the light of the expectations of the parties at the time of the contract formation.
I understand that, counsel, but what I'm trying to get a handle on is, for example, you've stressed twice the wrong mulch. Is it your position that simply using a different kind of mulch, without any argument that that mulch would not be effective, it's just more expensive, that use of that different mulch is so material that Bellissimo owes nothing under the contract? They are fully excused from their performance. Is that your position?
I believe, yes, that's one, I'm not prepared to concede that if you get what you're not paying for under the contract, you get a different product than what you've contracted for, that there's an obligation that arises on your end of the contract.
So if I contract to buy a Subaru, and instead they deliver me a Cadillac, I don't have to pay a dime for that Cadillac?
You didn't contract for a Cadillac there in that scenario. And to put this just a little bit more in light, I want to talk a little bit about the materiality of the contract terms. Looking at that contract, paying suppliers, a mechanic's lien, indemnifying the general contractor from a supplier's lien, these sorts of issues are clearly material terms.
Counsel, let me ask you, didn't Bellissimo have some recourse under the terms of the contract for Rocky Mountain's failure to do those things you're just talking about? Didn't it have the opportunity under the contract to offset any damages that may have been caused by their failure to pay the subcontractors or failure to indemnify or protect them against liens?
Right. So, yes, there were provisions in the contract dealing with offsets. There was also very clear contract language relating to when Bellissimo's payment obligation arose. And that, in the contract, it clearly states these terms, which include the mechanic's lien, paying the suppliers, indemnification, these sorts of issues, which are very important to a general contractor to prohibit, for example, having to double pay, being sued by a supplier, having the refinance or sale of the development held up, very material terms, that Bellissimo's payment obligation would not arise until those items were completed. The reason for that argument is pretty simple. The idea is there is going to be a delay until the proper paperwork is submitted. Then we will pay you. And that really is the fundamental issue that I believe the trial court erred on here, is the analysis that there was somehow an obligation by Bellissimo to pay amounts owed without any releases, without any guarantees that these sorts of invoices would satisfy the work that had been done, especially in light of the fact that the work that was done was not done pursuant to the contract. It was not what the parties had contracted for.
When was the first time Bellissimo ever raised the issue of the mechanic's lien waiver in their explanation as to why there was a delay in payment?
So there are 2 notices of default that were sent prior to this case being filed that highlight concerns that Bellissimo had with the agreement. Then at trial, this was very clearly an issue that the trial court considered, that counsel presented, and it was an argument that was tried. It also really has to do with, it's the first element of a breach of contract claim, when and whether a duty gets triggered under a contract and what triggers that duty.
So what's the answer to my question?
When was that first raised?
The first things that were raised were things like, this isn't a proper invoice. We don't have a signed contract yet. It wasn't until much, much, much later that anything came up from Bellissimo's perspective about the lien waiver, correct?
Correct.
How can it be so material to the contract if they didn't even think of it when it came to explaining why they were delaying payment?
Well, I think there were a couple issues here. First, the landscaper had performed half of the work in a week. They used the wrong mulch, and they sent an inflated invoice. Those were very clearly large issues. The second issue relating to the lien waivers, the supplier's lien, these sorts of items were first raised, I believe in emails around August 13th, around the time of August 13th, 2015, and then in the first notice and second notice of default on October 7th, 2015, and October 16th, 2015. Remember, the work was performed in the last week of July. So that was June 17th through June 25th, 2015. So,
Pardon me for interrupting, Mr. Walshine. I want to go back to Judge Tao's hypothetical about Subarus and Cadillacs. Your response to Judge Tao, I think, was basically this. I'm putting some words in your mouth, but if I get your intent wrong, please correct me. Well, we didn't order a Cadillac, so that's the breach. But of course, you can't keep the Cadillac. You give it back, right?
yes, I guess that's true. There's no contract for a Cadillac is, I guess,
Right,
my point.
Right, but if you keep the Cadillac, that's problematic, right? Because if the car dealer gives you a Caddy instead of a Subaru, and you keep the Cadillac, then you obviously have benefited, right? Because you've got a car.
Yes, I understand what you're saying.
So in this case, you didn't ask Rocky Mountain to come and tear out all the sod, did you? All the seeding?
No, that's true.
So you kept the seeding?
The seed was kept. A new sub came in and redid the area that RMHS seeded and the area they didn't seed.
Right, but you kept the seed.
Correct.
Why doesn't Judge Tao's hypothetical work then?
Well, because let's say I wanted to get a Subaru, but it was just a Impreza instead of a Legacy. I still don't have a contract for the Legacy, and if you give me half of an Impreza or half a Legacy, I'm not obligated under any terms of this contract. There's no obligation to pay under this contract. There may be an obligation to return some sort of car, but that's a lot easier said than done when we're dealing with mulch. I guess this is the problem I'm having with the analogy. It's the contract, the clear contract terms here were not followed by the trial court. The analysis the trial court applied on this contract was not to protect the general contractor from things the general contractor wanted to be protected from. Things like having a mechanics lien filed against it by a supplier, or having an inflated invoice submitted, not having its checklist followed, not having a significant amount of that agreement followed. I see my time here is done. So with that, we just ask this court to reverse the part of the trial court's orders entering judgment in Rocky Mountain's favor on Rocky Mountain's claims for breach of the subcontract agreement and finding the mechanics lien asserted by Rocky Mountain was not excessive. Thank you for your time.
Thank you, counsel.
Good afternoon. My name's Daniel W. Alexander, attorney registration number 16757. I'm appearing on behalf of plaintiff appellee Rocky Mountain Hydro Seeding. And initially, I'm going to just provide a brief overview of the case and why we're here today. And the reason why is that we have a contract that, according to Rocky Mountain Hydro Seeding, was to be determined based on a formula, verified field measurements, unit costs. Bellissimo's view on the contract was, this is a fixed price contract, period. You have to do the entire job for this price. There's an ambiguity there, because you see the formula set forth on the first page of that contract. On the payment voucher, you see a not to exceed. It's ambiguous. And the trial court at that point, if it's ambiguous, as a question of fact determines what the appropriate approach is. In this instance, the trial court determined, not surprisingly given the language, that the contract price was determined based on verified field measurement versus unit cost. It's not surprising, and in fact, that's one of the deemed admissions that was imposed upon Bellissimo, was that very issue. This is how we determine the cost of the contract in terms of the work performed. Now, I think telling here is that if you look at their termination letter and their notice of default letter, the notice of default letter was Trial Exhibit 11, it's record page 69. It's undated, but it's approximately a week or so prior to the termination letter, Trial Exhibit 13, record page 73. They allege two things in that letter. They allege, number one, that the work was not done properly. As we saw in the trial court, it's unrebutted testimony by the plaintiff's expert witness that the work was done properly. We were getting good growth out of it. It's what to be expected. The second thing they allege in that notice of default letter is you need to come back here and finish this job. Well, by then, we had already submitted an invoice months earlier. We're entitled to progress payments here. This is not a case where you get paid at the end. We submitted it, and as the trial court found, $55,000 approximately of that invoice should have been paid. They adjusted down for the hydromulch instead of the straw mulch, which, as the court has obviously caught on, is a much superior product. This was not a surprise. Before it was ever applied in the record, Michael Campana, the representative for Bellissimo, was advised that straw mulch was not available. He was advised that it would be an increased cost. As the trial court noted, this was not rebutted, but he didn't dispute it, but it was a change of method. Instead of the spray on wall, which was merely a difference in area. You know, I would have liked the trial court to give us the other one, but it got it right. It got it right on that. Cost us $40,000, but you know, you can't argue with it. So we have.
Excuse me. Sorry, I was going to ask you, if I remember correctly, all I saw in the briefs was that there was one involvement of another lien filed against Bellissimo, is that correct? That was involving a separate party that was involved in these proceedings that is no longer involved.
That's correct, and that's, quite frankly, it's a tempest in a teapot, okay? Because I think what's important to realize is on all of these breaches, well, of course, our contract was terminated before any of this other stuff was ever raised. It's a contrivance, including that mechanics lien. Our contract was terminated. The only two things that they were arguing about was you got to come back and finish this thing for the fixed price, and you didn't do it right. Well, we know that the doing it right part has been proved otherwise. There was no evidence presented at trial to say we didn't do the job right. The part about fixed price, we've seen where that wasn't applicable either. If Bellissimo had even said, okay, you've done half the job, we have a dispute about whether it's a fixed price or a calculated price, here's half, we would have a whole different case, but we didn't, and they terminated us. Getting to your mechanics lien thing, there was some sort of an error in communication there, and the mechanics lien was actually filed for materials that could not have been used in this job. It's completely outside the scope of the contract. We paid it off. And this is the big, big problem with their case. And this is why I say all these breaches are just a contrivance to get around the fact they wrongfully terminated the contract. As the court, I'm sure, knows, whether a party has performed its obligations under a contract, question of fact. Furthermore, whether a breach of contract is material and therefore excuses performance, also a question of fact. The trial court's findings in this regard cannot be disturbed on appeal, properly anyway, unless they're wholly unsupported by the record. We know we did the work right. We have a verified field service measurement and unit costs. That was deemed admitted, and it would have been admitted anyway. After they terminate, they start coming up with all these other reasons. And here's the key here. They did not present one single piece of evidence of financial harm caused by any of this stuff. Mechanics lien filing, make a big deal out of that. Well, it's outside the scope of the contract. The lien holder, with confusion between my client and them, it was a completely different job. Plus, we paid it off. We performed.
Counsel, you've reiterated twice that the materials subject to that lien or giving rise to that lien were outside the contract, but the trial court found that there was a material breach. Is that not also a fact finding that we must defer to with the same deference you're arguing for all the other facts?
I don't know that that's accurate to say that the trial court found a material breach. There were a number of breaches indicated, but again, we had already been terminated from our contract by the time any of this stuff came up. So there's nothing we can do at this point. Now, if you have a contract that's been wrongfully terminated and you have parties saying, well, we did this and you owe us this money, and they said, well, you did this wrong and you owe us money for this, you have to present evidence that that cost you damages. This lien that was filed there, it didn't cost them anything, nothing. They didn't pay any of the lien. They bonded over the liens, which was approximately 150% of the amount claimed by Rocky Mountain Hydro Seeding, which is normal, and that handled the other lien as well. The lien was gone. That happened very early and before my involvement in the case as well.
I will correct myself. I didn't intend to say material breach, but a finding of a breach is also a fact finding, correct?
That's correct.
The trial court, having found that there was a breach of the agreement by RMHS to essentially prevent their subcontractors from filing liens, is something we have to defer to.
Well, we do, and then this is where you also get into some contractual interpretation too. So if you look at Section 6 of the subcontract agreement, which is the part that pertains to lien waivers and this sort of thing, in there, until you receive payment, there is no requirement to furnish any lien waivers from third parties. I would argue that the intent of that contract provision is that, look, if you get a progress payment and we give you money, you need, and the language supports this, you need to give us lien waivers for all the materials that were there that we just paid you for. We never got paid. We never got paid. The contemplation there, to me, I think, is crystal clear to the extent any construction contract is. I mean, they're lawyer preservation contracts by and large, is that if we pay you, you have to give us lien waivers from everyone that has a lien right. That's what it means. And they get into this lien waiver issue on Rocky Mountain Hydro Seeding as well. The same thing is true. We don't have to give an unconditional lien waiver other than for the funds we've been paid. We have never been paid 1 cent on this job.
But at least, according to the argument from Bellissimo, you would have had to have at least given the conditional lien waiver in advance of receiving the first payment, hence the conditional nature of it, correct?
That's correct. And we get into that, and if you look at Section 6, it says in a form appropriate to Bellissimo. They never gave us any sort of a form. It wasn't part of their termination letter. When you have a requirement in a contract to give notice of default and you don't assert what it is that has to be taken care of, you're bound by that. They didn't tell us that the reason why we didn't get paid is because we didn't furnish a conditional lien waiver. They told us we needed to do the job effectively for the entirety of it for $50,000. That's not what the contract says. We are gone and out. Then we get into this situation where the court has ruled that, in fact, it is a formula contract, and you were wrong to terminate it. The rest of this stuff are an excuse trying to get them out of this jam. And at this point, I don't see how a trial court could ever find any of the breaches by my client to be material when there's been no evidence presented at trial, none, that it cost Bellissimo any money. And now if I could turn as well to the mechanics lien issue.
Actually, before you go on to that,
okay.
I'm curious, aren't you conflating two elements of a contract claim? Materiality of the breach is one thing.
Mm-hmm.
Damages are a separate element. The damages don't prove the materiality, do they?
No, I don't think I'm conflating them. How can a breach be material when it didn't cost you any money? That's what happened here. They're saying you didn't give us a conditional lien waiver. Did that cost them any money? No. They're saying you put on the wrong mulch. Did that cost them any money? No, it actually benefited them because under the trial court's ruling, we only got compensated for straw mulch, not hydro mulch. Now on
Pardon me for,
Mhm.
I'd like to test that just a little bit. Sometimes not costing money is one thing, but other things can be a subject of cost, like time. For example, it might not take more money to solve a problem, but it may take more time. And in the context, time might be important. Couldn't it be material if it cost more time?
Well, it may or may not. You know, I mean, usually if there's a time cost, it also involves a monetary cost. But let's assume it's something, it's hard for me to speculate where there wouldn't be some costs involved, but then we come full circle here. There has been no evidence whatsoever presented in this trial that any of the actions or inactions, faults by Rocky Mountain Hydro Seeding caused any sort of detriment to Bellissimo. None. There's none.
I'm going to keep going on this. Let's say that, not facts here, that there is some emotional value to someone that they want a specific brand of product, not for any monetary reason.
Okay.
They don't want Corporation X because Corporation X doesn't support their political views. So they want Corporation Y materials.
Okay.
And they find out, and they've made that very clear that that's essential to their contract to you. They'll even write it in writing, this is material to me. Is that not, even if it costs them nothing, is that not a material breach that would not, in other words, the damages aren't a part of the analysis of the materiality. They're
Well,
separate.
Well, two things there. Okay. Materiality, what is the remedy there? Secondly, you don't get emotional damages for breach of contract.
That's why I chose that fact pattern, because
Ooh,
again,
glad I caught that.
I would submit to you that I have stated what would be a material breach without any damages whatsoever. They are not necessary. One is not necessary for the other. They are both necessary to recover any damages, but one is not necessary to finding the other.
From an esoteric standpoint, I would agree. But in this context of this case, without a showing of damages, it can't be used to reduce the damage award that was awarded in the trial court. I only got 15 seconds here, unless we get overage time like in soccer. But on the mechanics lien issue, that's also a question of fact. And here, I outlined in the brief how the bottom line is, if they calculated interest at 18%, then attorney's fees wouldn't have been included in there. because at that time, the only $800 difference or so, and the 18% comes from the invoice that was sent in July. Where that $800 comes from, who knows? It could be an error in calculation. It could be a transcription error. We don't know. But what we do know is Bellissimo called Dwight Brummett, counsel for Rocky Mountain Hydro Seeding at the time. They called him after Rocky Mountain Hydro Seed's principal. They could have asked him, how did you get this number? He's the one who prepared it. They didn't do it. That's all we know. The exact number, we're not sure. And I think I've about equaled their overage time, so unless the court has any other questions, I'll wrap it up at that.
Thank you, counsel.
Thank you.
And court thanks both counsel for your arguments. Those arguments are going to be helpful to the court in reaching a decision. So this matter shall stand submitted, and a written opinion will issue in due course. Thank you very much. Counsel are excused. The court will be in recess, and the bailiff may so announced. Thank you.
All rise. The court will be in recess, subject to call.